Good morning. Though the subject maybe seems to be very hard to understand, but it is my bounden duty to make you at least understand the words being used by the Supreme Court while interpreting the statutes. So, time to time, some acts are being annexed, consolidated, like Jan Viswas Act, which brings a lot of acts scheduled therein to exercise Jana Viswas Act. Like that, earlier insolvency, Provisional Insolvency Act, and other two acts were there. That everything along with the companies Act, Insolvency and Bankruptcy Code was introduced. And do not fear to read that Insolvency and Bankruptcy Code. There are some minor provisions which enables you to approach courts to declare you insolvent if your debt exceeds from your assets. Sometimes clients may approach you. All those things are different and go through that. But here what my endeavor was that the Supreme Court has stated that what is legislation by incorporation and what is legislation by reference. This is what they say. The problem was Section 435 Companies Act. A punishment clause was incorporated under Insolvency and the Bankruptcy Code. Special court was also established, but subsequently what had happened, the Companies Act was amended. Therefore, the aggrieved person who was prosecuted has approached the Honorable High Court stating that the provisions since the Companies Act was amended, this 236 of the Insolvency Code is not applicable. But this is what the Supreme Court has said. The reference is not general but specific. Therefore, the present case is legislation by incorporation. That means both the acts sections were merged with the primary act of code. This is what they say. Under Section 236 of the code, it is provided that offences under this code shall be tried by special court established under Chapter 28 of the Companies Act 2030. Therefore, they say, since it is legislation by incorporation, the provisions are applicable, and Insolvency Bankruptcy Code authorities like the competent court to initiate prosecution. See, this is the case AR 2024 Supreme Court 2835, wherein Insolvency and Bankruptcy Board of India versus Satyanarayanan Bankatlal Malu. In this case, these few words you have to remember: legislation by reference and legislation by incorporation. That is most important. Then you must also understand that is what is meant by moratorium. This is when insolvency proceedings are initiated by appointing a professional, interim resolution professional, that is called RP. Those things are most important words. At least for time being, young lawyers may understand this and try to, if you are interested, you go through and dip into this ocean of subject. And when you reach the shore, you will feel proud that you are eligible for Supreme Court judge. Best wishes.